Committee this Wednesday morning, March 12th, and we're going to start with a walkthrough and one witness on H409 related to bail revocation. Over to you, Eric.
Thank you, and good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel here as the chair indicated to give the committee a quick walkthrough of H409, which is an act relating to the procedures for bail revocation. I should mention at the outset that I'm actually not even second string, I'm third string on this bill because it's actually Ben's bill, but he couldn't make it because he's out with a sick child today, and then Michelle was going to pinch hit for him, but she has to be in the Senate. So hence, I am third string, which probably will go a long way toward giving you some baseline knowledge for how much I know about this bill. It charitably be called not much. But I have taken a look at it, and so I'm ahead of the game in that regard, and I think I understand what's going on. So happy to help the committee get a sense of what it is. And in the big picture of what's going on here, it has to do with bail revocation procedures. Does two main things, I think. It creates a procedure for bail revocation procedure, right? What you have in law now is sort of a standard for when bail can be revoked. There's not much real detail on what the procedure is. So it does that it describes and details what the procedure for bail revocation is. And as well, it tries to align the standards for bail revocation as well as the procedure I just mentioned with the constitutional requirements that have been established by the Vermont Supreme Court. So you got those two things going on. Establish the procedure, try and align everything with the constitutional requirements. And that's kind of, as I say, the big picture. And also, Section 1 really deals with that big picture. This is the intent, which is, as I just mentioned, it's the intent of this bill to align the bail revocation standards and procedures with the constitutional requirements that have been established by the Vermont Supreme Court. So that's essentially what Section 1 says. And specifically, you'll see the last line 18 and 19, page 1, that it trying to expand upon what it means to disrupt the prosecution. Yes, sir.
Question for.
I hate to do this to you because you're new at this. But why isn't this already aligned? Why is this just coming to us now and it's not aligned?
I have no idea.
You didn't do your homework.
No, I did do my homework, but
Just for the record, for people out there in La La Land, I'm messing with you right here because I know you were thrown into this, but I don't understand why it wouldn't already be aligned.
I think it's a matter of like, there's always sort of a back and forth between the court and the legislature. So when the court issues a new decision, says, hey, there's a constitutional issue here, then the legislature can respond and say, well, okay, we read that decision and now it's how we think we need to respond to adjust the statute so that hopefully it complies with the decision.
So it's kind of all just new stuff all the time that's being adjusted.
That happens all the time. Yeah.
Okay.
Exactly.
All right. Thank you.
Good thing. So that last phrase there too, on the very bottom of page 1, that sort of specifying what the constitutional intent here is, that is to create this language so that the disrupt the prosecution basis for revoking bail is consistent with this Vermont Supreme Court precedent. And on that note of disrupting the prosecution, turn over to page 2, and you'll see Section 2 in existing law, and this is lines 3 through 15. The basis for which bail may be revoked is in current law. That's 1 through 5. So it says bail may be revoked entirely if the judicial officer finds that, and then there's 5 different reasons that the court could find that a defendant's conduct warranted the revocation of bail. And you'll see in the second one, that's where this disrupt the prosecution language that I just mentioned in the legislative intent, the language has changed a little bit. So one of the reasons that bail may be revoked is number 2, if there's repeated violations of conditions of release in a manner that disrupts the prosecution of the accused. So let's take a moment and go out of order there, because that term disrupts the prosecution is then defined in your new bill. And that's over on page 4, line 13. So you see the term is clarified to disrupt the prosecution, which my understanding is to be consistent with these Vermont Supreme Court decisions. And then you've proposed to add a definition of, well, what does that mean? Disrupt the prosecution here. And you laid out the language here. It means, in addition to any other meaning recognized by law, committing a criminal offense, that could be one, you commit a criminal offense, or you violate the conditions of your release, if you're the defendant, if you've been released pending trial for another offense, and you demonstrate that there's no condition or a combination of conditions of release that will reasonably mitigate the defendant's risk of flight, or reasonably mitigate the defendant's risk of public safety, or reasonably ensure the defendant's compliance with court orders and appearances. So there's your definition of what disrupt the prosecution means. So if you're a prosecutor, say, or the court, and you want to file a motion, which we'll get to in a second, the procedure, but if you want to file a motion to say, hey, revoke this person's bail because they disrupted that they've engaged in, let me see, turn back to that, I'm turning back to 2 line 7. Hey, they've repeatedly violated their conditions of release in a manner that disrupts the prosecution. Well, there's your definition of what you're going to have to show, what you're going to have to put into evidence to show, here's what this defendant did that created this risk of release that, there's no, this risk of flight from public safety, or this demonstration that nothing that we can do can reasonably ensure that they're going to comply with court orders. That's your standard as your prosecutor or your court that you're going to have to prove in order to persuade the court to issue an order revoking the person's bail. So that's how that works in theory.
You can ask a question.
Well, Eric, can you remind me the thing that just raised a question, an alarm bell for me, I guess, is the risk to public safety, to mitigate the defendant's risk to public safety. If I'm remembering correctly, I mean, is that a condition of an allowable condition of bail in the first place?
I don't recall that. I'm not sure.
Seems like we're adding.
You're, yes.
Okay.
And we'll have other witnesses definitely talk to that.
Okay,
I remember flight. Risk of
yeah,
flight.
that's what I like.
Public safety is for the other criminal charges. So, pretty sure. I'm looking at.
I mean, yeah, if it's a violent crime against a person.
Right,
the evidence
right.
is great.
Yeah.
Right, there was that narrow pathway
Correct, for,
for
Holding
considering public
without bail.
safety. Yeah,
Yeah.
okay.
so I mean, I look at this as kind of like holding without bail.
Yeah,
But there's, if it's according to case law, which other people will be talking, I'm sure, a lot about. There are instances where that can happen. Well, whether this is one, we'll.
okay, I guess, yeah, that's my broader question is both the reasonably mitigate the defendant's risk to public safety, reasonably ensure the defendant's compliance with court orders and appearances. It seems like we're broadening what you could originally institute.
Yes, possibly, maybe, we'll see.
Okay,
So we're gonna be hearing from witnesses who will find this to be unconstitutional. I anticipate our next witness will be sharing with us why it is unconstitutional. I'm not so sure it's constitutional myself, and I have to be convinced by other witnesses that, in fact, maybe there is an argument why it is constitutional. But this is to put it out there for that discussion, and so that'll be the heart of testimony that we'll be receiving the next couple of days.
great. I just wanted to check my,
Yes, you absolutely were remembering
Okay.
Dale correctly. Over to you, Eric.
Thank you. And on the constitutional question, that is sometimes something that our office will offer an opinion on as well. But in this particular case,
well,
having not read the cases, you wouldn't want to ask me.
okay, fair enough.
Yes. All right. So so we just talked about what reasons may bail be revoked for, right? That's in subsection A. Now, subsection B that's added is, well, okay, if bail may be revoked under subsection A, if one of those reasons exists, well, what's the procedure to follow? And that's what subsection B is. Here's the procedure that has to be followed. Subdivision 1 there, bottom of page 2, this says the prosecutor or the court can make a motion to revoke bail. So that's step 1. Prosecutor or court can make the motion. Over on the top of page 3, subdivision 2, if the motion is made, state has the burden of proof by preponderance of the evidence that the accused engaged in one of those 5 bases that we just described in subsection A. So the state has to show by more likely than not preponderance of the evidence that the defendant did one of those five criteria that we just indicated, can support a motion to revoke bail. Subdivision B has to do with evidence. So evidence can be presented through affidavits or sworn statements as long as the defendant has the opportunity to present their own direct evidence. Subdivision 3, that references Rule 3 of the Rules of Criminal Procedure, which is the rule about arrest without a warrant that outlines situations when arrest without a warrant can be made. So this says, well, notwithstanding Rule 3, which generally lists, hey, if you're going to arrest without a warrant, these are the offenses for which you can do it. This says, notwithstanding that, a person can be arrested without a warrant for purposes of an order revoking bail. So if the court issues an order revoking someone's bail, then the person can be arrested without a warrant. Subdivision 4, this is an interesting one. This is sort of like almost like a motion to reconsider. This basically says that after the court issues this order to revoke bail, either the defendant or the prosecutor can seek review of that. So they can file a motion to say, hey, we want a second look at this for whatever reason. Maybe there's changed circumstances or something different than what was understood in the initial order. So there can be a motion to review it by either the prosecutor or the defense. And lastly, subdivision 5 just says that the bail bond can be forfeited as well. So if somebody's bail is revoked, then the prosecutor can make a motion to revoke the person's bail bond or forfeit the person's bail bond, I should say. All right, so that's the procedure for this bail revocation process. Subsection C has to do with the order, the court order. So what's there? The court's going to issue an order to revoke bail. What does that have to be based on? When can the court issue that order? Well, first of all, line 19, page 3, there has to be notice to the defendant and a hearing. So it can't just revoke unless the defendant has provided notice and they have a hearing and opportunity to contest. Now, if they do have those two things, well, the court can issue the order only, and this is line 20, only upon a finding that a legitimate and compelling state interest exists to revoke bail. So there's this required finding. You have to have notice in a hearing, and there has to be a finding that there's a legitimate and compelling state interest for bail. Over onto page 4, there also has, this is subdivision 2, top of page 4. This order also has to make a specific finding that the state has met its burden of proof. Remember, we just mentioned the state has to prove by a preponderance of the evidence that one of those 5 reasons for revoking bail exists. Well, it has to be specifically in the court's order that the state met that preponderance burden of proof, and with respect to whatever allegation is made about the defendant's conduct that supported the revocation. And lastly, subsection D there has to do with some issues regarding speedy trial. So what's the procedure if the bail is revoked? Once the court does issue that order, then there's a requirement that the defendant's case has to be set for trial within 60 days after the bail is revoked. And if that doesn't happen, then the court has to immediately schedule a bail hearing. That's in subdivision 2. We already talked about the disruptive prosecution language down at the bottom of page 4. That's connected to the basis for revoking bail. That's back in section 2. Says the person's bail can be revoked for repeatedly violating conditions of release in a manner that disrupts the prosecution. This fleshes that out by defining disruptive prosecution. And I think that's it. Yep. Will be as of July 1st, this year effective date. Yep. That's covers all the info I've got. Any questions?
I have a question, but I'm not, I'll ask you and then if that's okay. and
Yeah.
you'll Tell me.
Yeah.
You know, I'm just wondering, on page 3, line 9 and 10, the just arresting without a warrant.
Right.
What other, are you aware of, is that a common provision? You know, are there a lot of examples where?
Yes, there's a lengthy list of examples.
Okay.
It is, by my experience, more often the case that that when you add, there's a lengthy list there in Rule 3. So typically, like you may remember, I think we did it last time I remember doing it was a couple years ago with the crimes against healthcare workers bill. I remember adding a provision for arrest without a warrant for that. But from a technical perspective, I feel like most often that's done by adding to that list in Rule 3. That doesn't mean it's incorrect to put it here. This is another way to do it, but most often the way I've seen it in the past is that, but I think both ways from a technical perspective work. But yes, there's a fairly solid list of exemptions to the general rule for no arrest without a warrant.
Great, so that list is contained within the rule.
Correct.
Okay. Thank you.
Yep.
No other questions?
Yeah, right. Thanks.
Thank you, Eric.
Yeah, sure thing.
Rebecca?
All right. Let me know if you have anything else you want me to pass along to Ben. Let me know.
Haven't seen you yet.
No, thank you. I was telling Representative Longo, this is my first appearance in the State House this session.
Oh,
Oh, no,
that record going this long into the session.
I've been deep into casework. So that's good to see you.
Morning.
Morning. Should we get going then? All right. For the record, Rebecca Turner, appellate defender at the Defender General's office. Thank you for inviting us, and I am kicking off the witness testimony. This is an alarming bill. Right. This is alarming, and as well as has already been revealed. I'll go through and explain our concerns, and really the concerns are that it's just not consistent with the Vermont Constitution, several levels. And I understand the intent of this bill is to make it consistent with the Vermont Supreme Court's decisions interpreting the procedures for bail revocation consistent with the Vermont Constitution. This language is inconsistent with the plain language of these decisions. So I'm going to, for the record and for Ledge Counsel who will be working on this, I'll put some sites in to pinpoint. I didn't have time to do a PowerPoint slide where I was going to do a direct comparison of the quote of the decision but I'll try to do the next best alternative. So, yeah, there was a question as to why this hasn't been done previously. It's astounding. The last time this was amended was 2017. I think in reaction to State v. Gates, which is one of the cases that is cited in the intent section to bring it into consistency. It is true. State v. Gates, State v. Solve are going to be the two primary decisions I'll be focused on today. And that was the focus in the drafting of this bill. It is because they are the guiding decisions from the Vermont Supreme Court interpreting the Vermont Constitution, Chapter 2, Section 40, consistent with bail revocation. Also to give sort of a sort of broad-based starting place based on the questions. Unlike the US Constitution, the Vermont Constitution has a presumptive right to bail, pre-trial, right, consistent with and actually shoring up the presumption of innocence. It's all wrapped up, right to bail, unless you fall within two exceptions. You've been charged with a crime where involving life imprisonment as a penalty, or where there is an element of the offense involving violence against the person, a felony. This bail revocation statute, however, applies to all offenses. So it's not just limited to the life imprisonment or the 7553A cases involving an element of use of force. And that's significant because every other charge out there then is there's a presumption to release pre-trial. And so the procedures that get applied in this overarching bail revocation statute, the only one we have, 7575, has to be compliant with and consistent with the preset starting place, which is the right to release, right to bail. So starting there, let me go with page 2. And I'm just going to go in order of this. If you want to jump around because it makes sense, just let me know. So this first section A is what is in the current statute. It lists 1 through 5, the different factors, bases for bail to be revoked. Now, if you're going to take an opportunity to make this and bring this up to date, consistent with the case law, section 5 has already been struck down. And that was struck down in State v. Gates, paragraph 22. And you'll see here a theme is the mere violation of condition of release, either a single violation or numerous violations, is that enough to revoke probation fundamental right to bail? No, that's a repeated holding in Sov and Gates. You cannot, standing alone, have just a single or 50 violations of conditions of release. That's not enough to revoke bail. Number 5 goes to whether or not a charge of a felony, which has been found to be supported by probable cause, a new charge. Another charge of a crime supported by probable cause or not is not enough to revoke probation. So think about a new charge, new criminal charge, any number of new criminal charges, any number of conditions of violations of conditions of relief, not enough to revoke. That's our starting point with Gates and Sov. And they go deep into why that is, right? Because again, we cannot use the revocation of bail, meaning coming back into jail, retrial, presumption of risk, without violating the Vermont Constitution, because that is preventative detention. That is a punishing someone before the fact, right? Or something else. So it has to be, the only justification to impose bail in the first place is to avoid risk of flight from prosecution of the underlying crime, not for other crimes, right? You deal with bail questions with that charge, with that docket. Does that make sense? So there's no blurring. It's a very pure and limited question as to what supports the revocation. So if you're going to clean this section up and bring it up to the law, that section 5 needs to be struck. Again, taking a look at paragraph 22, State v. Gates sets that forward. The real heart of this.
Yeah, go ahead. Just before, does Gates address the or an offense similar to the underlying charge?
No, no, it's not. It's not.
Because I hear on the violation of condition of release and I hear on the felony
Right,
or crime against
right.
a person.
Right.
So that's just that other language.
Right. That is not enough, again, because the heart of it is that there's a some presumptive right to release. And if you're going to revoke bail and the right to bail, there's got to be a showing by the state. I'll get there, but I can go there.
No, you don't need to go there.
All right,
And
right.
I understand.
Right.
I understand all that. I'm just curious if that the language around a similar offense was also in Gates or if that.
Oh, I see what you're saying.
Yeah.
I can't remember the factual settings on that one. It wasn't determinative.
Okay.
That's what I meant to say, to be clear. So then the heart of it will be, so factors 1 and 3 on this list on page 2, that's been reviewed by Sov and Gates, and that's been upheld as consistent with the Constitution. And that's because 3, for instance, violation of conditions of release that constitute a threat to the integrity of the judicial system. They gave examples of what that is. It's very, very, very specific and extreme. Destruction of evidence, right? Endangerment to a state's witness. Those are examples of the integrity to the judicial system, as understood in this narrow context of right to bail. So number 2 is where we're going to go. I'll talk more about it. And here the proposal is to change the language impedes to disrupts, plain language. I'm not sure that's significant, but it is significant when you get to the definition section that is spelled out, and that's where the concerns are raised. The other thing before I move off of page 2, moving to procedure, this section is entirely new. And here B1, line 18, line 19. Can you, yeah.
Back you up, did you have any thoughts on the fourth? I think you said 1 through 3 have been explicitly.
Yes. And I did not see any case law by the Vermont Supreme Court reviewing and upholding this. So B18, 19. So this procedure, this subsection goes to who may move, revoke bail. This language here in 1819 adds, does not exist in current practice, permits the court on its own move to revoke bail. So that is of concern. Whenever we see any allowance of the court to act like a prosecutor, that raises serious fundamental concerns of separation of powers and violation of party presentation principles, which is fundamental to our adversarial criminal justice system. Deep roots in common law. It is just this principle that we have these lines for a reason. We need the judiciary to be impartial. If we allow here the judge to make this motion to revoke bail, we are jeopardizing the integrity of the judiciary and blurring those lines. We have, if you look in the criminal code and law, to the examples where there are these limited exceptions, where the judge can make motions on their own. They are 48, I think is it 48, Rule 48 of the Criminal Rules of Procedure. Maybe a judge may on its own motion dismiss a prosecution. Very, very exceptional power because that goes right against the prosecutor's discretion to charge. But there are certain allowances to protect constitutional rights of the defendant, but there's a long list. It's very difficult. After trial, after evidence has been presented, the prosecutor has charged a certain offense, the judge is permitted to motion on its own and add a lesser included charge, right? Not asked by the parties. It's just an exceptional power, right? And so this is something that was snuck in, is not supported or suggested by any of the decisions Gates or sought. Those came up by way of a motion by the state to revoke. So I'm not sure why that's there. It's extraordinary. It alters the balance of powers, and I think jeopardizes the integrity of public confidence in the judiciary. We don't need it. I don't know if this is an attempt to get around certain prosecutors who may not be prosecuting certain types of cases. I don't know if that's the workaround here. I don't know what the motive is, but I would be asking what is going on, because that is not practice, and it's absolutely extraordinary. Moving to page 3. Page 3, the first few lines here, sets forward the burden on the state, and that is supported by case law. It is higher than probable cause. It is more likely than not, preponderance. Again, that's reflecting the fact that there is a presumptive starting point of a right to bail. And these conditions and other things that could be the basis to the revoke aren't necessarily some of themselves. So then 2B sets forth what's the type of evidence that the state can present to support its revocation. And here, this is directly contrary to current case law. Here it says it may be shown, the state may prove its case through affidavits or sworn statements, not live testimony, not live witnesses. That's been directly challenged repeatedly and agreed, the Supreme Court has agreed, you need more, the state needs to prove more. And that is in State v. Sauve, page 577. There's a quote, must be based on more than affidavits and sworn statements. State v. Brooks, more recently, 2015, VT 13, paragraph 5. The prosecution has to introduce some live testimony, which could be supported by an affidavit in addition. And again, this is because the Supreme Court has recognized the weightiness of this moment of having someone out, and now the state is trying to revoke and bring them back in.
What was that? What was the second case?
State v. Brooks, 2015, VT 13, paragraph 5.
And could you reread the quote from Saab on 577?
So I'm cutting through to just the middle of the sentence. Must is sort of the middle, but it must be based on more than affidavits and sworn statements. Yeah. Now, of course, the defendant has to have the opportunity to present direct evidence, but it's also because the state has the burden to present direct testimony as well. They cannot proceed on the papers. All right, so that is not consistent. The question was asked about number 3, and this is allowing for after bail is revoked, after issuance of an order revoking bail, law enforcement may arrest someone without a warrant. So there's a cross-reference to Rule 3. As the Legislative Council said, Rule 3 does list a number of situations where you can arrest without a warrant. All of those situations involve the charging of a new crime. Misdemeanor, felony. They have different categories of how to address it and when they're warranted. But critically, there has to be probable cause of a new crime. Here, it's allowing a warrantless arrest of someone who has a fundamental right to bail, right? So it's just, there's no new crime committed. And they're being arrested because they don't show up. This segues actually to line 19 at the bottom, and I'll jump there. And this is after notice to the defendant and a hearing. Bail may be revoked. So now this is jumping to before, right? Who may move to revoke? Current law state. This proposal allows the court. I've already talked about that problem. Here, this requires notice prior to. It makes sense. It's fundamental due process. We don't have that in writing. If the legislature is going to amend 7575, you should make clear what the notice is and what's required. We are having absolute problems with the failure to give adequate notice. I'm hearing reports from the grounds that this can unfold in various ways. The prosecution comes into court because there's a status or some other reason, asked to move to revoke bail, and the court decides later that day, holds a hearing, and the client hasn't shown up because it's a status. And then there's a hearing, and there's no time for the defense counsel to prepare the case, to even get notice and review the allegations, and then all of a sudden bail is revoked. And so that is a huge problem. Also, the notice that defense attorneys get from state's attorneys moving to revoke bail is done orally or in written and form, but oftentimes it's orally and really informal. Again, this fundamental problem where we've got such fundamental rights at stake is combining to really create situations where you just have no time to understand the case against your client, get your client there to talk to them. And now when you go back to this allowing and carve out exception for warrantless arrest, it's a setup, right? Inadequate notice, the hearing is held later that day, your client is not there, and now they can be arrested, right? That's crazy. All the situation that could unfold under the language here, where there's no new crime. Does that make sense? And so that's significant. Of course, Article 11 of the Vermont Constitution requires a warrant. That is the starting place. Okay? Every action that is allowed by this legislature, presuming action without a warrant, is presumptively unconstitutional as the Vermont Supreme Court approaches it. You know, the statutory rules of construction generally is we try to read every statute coming out of the legislature, or the Supreme Court does, consistent with the Constitution. The one exception is when you carve out in black and white text an exception to the warrant requirement. So just that's another heads up.
So would you have suggestion, and you don't have to have it right now, as far as the language that would help with notice?
I was looking by way of examples of what is currently in the rules of criminal procedure. For instance, right now, there's a requirement to give 14 days notice if a party wants to proceed with video conference, right? That's 14 days notice.
So it's a timing issue as well as the form of the notice.
Yeah.
Okay.
Right. So ideally written and timing to allow time to actually present a case. So even just allowing for video conferences 14 days is not criminal practice. When a defense attorney wants to put notice of an alibi or certain kinds of affirmative defenses, Rule 12.1, it's a 28-day notice. Now, of course, there's exceptions built in with that language if the judge so finds it's necessary, et cetera, et cetera. But those are some examples of time, right? Certainly more than what is happening and unfolding, which is same day. Right? Going to the forfeiture section on page 3, this is number 5. Lines 14 through 15. So here, again, this is now going to, so this is after a revocation order has been issued.
So can you show me where?
Page 3.
Okay, thank you.
Lines, and I'm going to focus on 16 and 17. This is about permitting a prosecutor to move to forfeit bail in accordance with the bail forfeiture statute 7560A. When there's a bail revocation order issued. So there is a decision from the Vermont Supreme Court. This is inconsistent with case law, and specifically State v. Brown, 2005 Vermont 104, paragraph 10, State v. Brown. There cannot to forfeit bail, you can't employ punitive measures to forfeit bail as a method to enforce conditions of release. Again, this is tied to this baseline approach to all things relating to bail. The only purpose is to ensure against the risk of flight from prosecution. Here, if you can revoke bail based on this new and expansive definition and grounds not tied to a nexus, right, of the issues of the prosecution here, this becomes punitive and in violation of State v. Brown. So this section is also should be also removed.
Ken has a question.
If there are no show in court, can't the judge warrant a bench warrant?
Yeah, yes, the failure to appear, absolutely, that's different though than, and that's getting the judge to issue the warrant. So there's no, are you back to the warrantless arrest provision? Yes, so again, that happens, but
Frequently, right?
what I don't understand is what's the problem being addressed here? Because there doesn't seem to be a problem as I understand it in practice. The state will ask, and the judge will issue an arrest warrant when there is a no-show. But here, it's just jumping that. It's not even allowing for it. It's just saying that no law enforcement can just arrest without a warrant. Again, what is the incentive to that? Is that because there may be a situation where the prosecutor doesn't ask for an arrest warrant, and this is allowing, again, a go-around of a prosecutor's exercise of discretion? So to me, I don't understand this. It's unconstitutional. I don't understand the motivation. There's no problem. The judge can issue an arrest warrant, right? This is about, seems to me, again, I don't know, the question to be asked, what is the motivation here? It seems to be a workaround of the prosecutor's discretion.
So the motivation to me is to make sure they are showing up in court, because they're not. Isn't that the motivation?
Yes,
Is to try to force them to show up, and because they're not doing it? So that is the problem, right?
I understand that's the motivation. This is getting to this issue of multiple violations of conditions of release and moving these cases forward. The issue about getting someone there by way of arresting them to showing them up, right? Now that's police powers to do it. How can law enforcement, consistent with the Constitution, arrest someone? Well, they do it within a warrant. So you get a court to issue the warrant. Again, this isn't a problem that seen. So I don't know why the carve out exception for a warrantless arrest. That's unclear. So page 4. Page 4. Speedy trial section. This is brand new. This is a brand new proposal that's not supported in the case law. It's very interesting to read it a few times. This is sort of tracking a speedy trial right in the limited instances of 7553A cases where the right to pay bail isn't attaching. It's not a life imprisonment case. It's the cases involving a felony and involving elements of use of violence against another person. So that speedy trial right is written into the Vermont Constitution in that limited exception to the presumed right to bail. Here it's being extracted, and on one level, if a defendant is going to have their bail revoked and they're sitting in jail, then this guarantees, right? The court shall put the case forward 60 days from the date of revocation. So it seems to give a defendant a new right that they don't otherwise have. Now, I'm sure you'll hear from others how this will impact our court backlogs and putting these cases up as top priority for trial ready as compared to other cases that have been sitting longer. Right? And should perhaps go further. The other concern I have here is line 5. Line 5 references that, and the question I have is what case gets set 60 days from the date of revocation for trial. What case? Now, this is coming in the context of violations of conditions of release. Conditions of release are imposed after the underlying criminal charge is filed, right? And so what we're having, I think, some concerns with is just these repeat cases of people violating conditions of release, themselves new crimes, right? Themselves new crimes. There's multiple crimes being charged, but fundamentally they relate to the underlying crime. Now, if this language in 5, this is a vague reference, which case is going to trial? Is it the underlying criminal case that started this whole thing off? Or is it the violation of condition of release that happened 5 years ago? Or is it the one that happened 1 year ago? Or was it the one that happened 6 months ago, right? So this doesn't necessarily get to the heart of it, because even if this allows for one VCR case or a slew of them to go forward, but the underlying conviction, the underlying charge isn't yet going to trial, and the defendant is able to win on the underlying, then those VCRs should never have happened in the first place, right? So it's which is coming first, chicken or the egg, right? If you're going to have a speedy trial and really move these cases and have this new rate, it should be that the case at issue that gets moved to the top is the actual underlying crime itself. Otherwise, you're actually not changing or moving things. And this is already going to create an enormous change in the court's trial scheduling, right? But if you're going to do this, then go to the heart of the matter. Go to the underlying crime itself being charged, not to the VCRs that are following. That doesn't solve anything, because you still have that underlying crime there. And worst of all, if there's actually, the state can't meet its case, and the person who was presumed innocent actually has charges dismissed, all of that was delayed even more. So it's, so what is the intent of this speedy trial? It can work against our clients in some ways, but it is an interesting rate that may be favorable for a person in a given case and may not be. It may be that a client needs more time. Defense counsel needs more time to prepare a case. And 60 days is too little time.
So isn't that on section 2 there that allows delayed by the defense counsel?
Not true.
That's true. If we move to continue, that should be then
Right.
counted. So yes, I mean,
Does that take care of your concern on that?
I think so. If they move to continue, they vote because they need more time.
Angela?
So I guess, well, I don't know if my question becomes moot considering number 2, but what you just described, the situation you just described, and if the underlying case is the one that is brought up, within not more than 60 days from the date of revocation, might that in some way provide a perverse incentive for people to violate their conditions of release? Like,
I think that it is. I don't know about the incentive or not in terms of it, but it could be a situation where it doesn't address those issues necessarily, right? In terms of clogging the court and bogging things down. Like if the intent is to move things along, I'm not sure this achieves it. In all honesty, I'm not sure.
Right. Yeah, I'm not sure it does either. And I'm wondering if it also adds this. I'd see that as an incentive if, in some cases where you're charged with a crime and you want a speedy trial. If you're given conditions are imposed and you violate those conditions enough times, or you could end up jumping the line.
I mean, it's presuming though a lot of things in that statement. I mean, presumes what is the motive or intent to violate conditions of release. And in some instances, and in many instances, these conditions are just onerous. And again, they don't have to be new crimes. They can just be addressing, limiting use of alcohol or drug use, right? And you're dealing with a complicated set of factors where there's not an intent to disobey a court order, primarily, but other reasons, right? For other person's background. So, so if it's going to be, if 5 is going to be in there, there should be language added to make clear that it's the underlying criminal case. And in fact, oh, yes,
No, before you have Ian and then Kenny has a question.
Just I want to clarify, I'm not sure if I heard you correctly for line 4 and 5 on page 4 in the speedy right trial, right to speedy trial. So I think you said that doesn't pass muster. And I don't understand why that would be if under the 7554A holding out on a non-life imprisonment case, that basically we're saying, all right, in those instances, we're removing the presumption or bail. And so in those cases, you're gonna get a trial in 60 days unless you waive it. So in this instance, it sort of seems like we're doing the same thing. We're like, okay, we're taking away your presumption of bail because of these other things. So you're gonna get that 60-day. Why in this instance with that?
so in the 7553A,
7553,
60-day bail right cases, those are always involving the underlying crime at issue.
There we go.
It's the felony. It's the serious felony that the Constitution has
Thank you.
carved out an exception. Here,
It's
it could be
Yep.
a misdemeanor VCR,
that's,
where the condition violated is not a crime.
thank you. That
Right.
helps.
No, it's okay. It's confusing.
So I'm confused. This bill has to do with violation of terms of bail, right?
It has to do with it. It is a part of it, but the Vermont Supreme Court has said repeatedly that's not enough to revoke that, right? That's back to Gates and Sov, and it's not enough. Committing a new crime by itself, not enough. Violating any number of conditions, not enough to revoke bail, consistent with the Constitution.
But they get notice to show up for bail and they're not, going back to my original point, correct?
So if there is concerns about how we can force people to show up, right? There are contempt powers of the court. There is the ability to file, the VCRs. But in terms of this, and this is again focusing on bail revocation, in terms of how we can revoke bail, it's limited. The legislature is constrained by the floor set by the Vermont Constitution, right? Because there's a presumptive right to bail. You can't use it to punish someone. You can't. That is the very definition of an unconstitutional use of bail, right? To punitively punish someone who is again, it's the only way to deal with bail is to deal with the risk of flight from prosecution, right? Now, I understand your concern about, isn't that this, right? Isn't the someone not showing up is not pursuing, is risk of flight or prosecution. Again, you're in a situation where the person has already been granted bail. So now it's about taking it away. And that's where the Vermont Supreme Court has said that there is an additional requirement than just mere violations of conditions of release. So reviewing Gates and Sov in depth is really helpful. There's just a wonderful write-up and explanation if there seems to be a disconnect. But I think the way that I get my head around it more easily is it's the starting place. It is the pre-trial right to be released. So once you have that, when can the court revoke it? It has to be more than just mere violations of conditions.
So I keep hearing, or I think I am, like incentives to show up for bail and all that stuff. It's like, it's a law to show up, right? And they're not showing up, and then more crimes are committed, and then we get more of a backlog in the system and more crimes if they commit more crimes and all that stuff, and it just adds to the judicial problem, right?
There is a problem. The question is whether you can solve it this way through the replication statute. And so what I'm trying to share is what the case law says establishing. So I want to point you to the places where it's inconsistent and where this will be open to being challenged. Let me go now to the heart of this, the disruption of.
I just have one question before you go there.
Yeah.
So what's the point in having bail for crimes then if we're not going to enforce it? I mean, if we're gonna set bail, right? It needs to be imposed, right? It needs to be followed through, right? We're not doing that, are we?
If if a court orders bail or release, right, release pretrial, then that is their right. They have liberty interest. If the court wants to revoke it because there have been violations of the conditions of release, right, violations of the terms of release, these are the procedures that have to be followed.
So I understand that,
Yes.
but they keep violating them and we keep adding on to the problem with we just keep letting them go. Like, how do we hold them accountable?
Well,
And this bill isn't working to do that?
this bill could not do it the way it's proposed consistent with the Constitution. So your question and you're seeking a solution. You're the policy maker. I'm here to tell you that a proposed solution by way of changing the revocation statute in this way and the procedures isn't consistent and violates the Constitution. So not denying that there isn't a problem. It's just that they can't be solved by way of this specific proposal. And let me go through and because I don't know how much time.
You're fine, just.
Okay, I do have time.
To just one, I guess maybe to follow up, a piece would be if having the original charge be seen in court sooner, like that would be a way to address it because it'd be getting addressed. That's one of the things that we're navigating. But I also want to clarify that this is specific to Vermont's constitution around bail, which I think just gets confusing because you hear about maybe things happening in other states or other ways of doing it. But we need to be very clear that in Vermont, everybody has the right to bail, right? That's the piece that's
That's right.
different here.
That's right. It is. You're right. And the Vermont Constitution is our Supreme Court, our supreme law of the land, right, for our state. And you're right. It is easy to hear how it's being done in other jurisdictions. And the United States Supreme Court's law relating to bail under the Eighth Amendment is not the same in terms of our Vermont Constitution. It is less protective. We have more protections. There is a right to bail, except for those two narrow exceptions, right? Life imprisonment cases and the felony cases involving violence as an element of the offense.
So if I may, our Vermont Constitution, the way it's written, with our bail as it's written, we're not dealing with the problem. We're enabling them to just continue to do bad habits, for lack of a better word, instead of dealing with the problem. Wouldn't you agree with that?
I'll rephrase and say and agree that the Vermont Constitution does not allow for exception to the right for bail based on multiple violations of conditions of release. That's right. If the people of Vermont wanted to amend the Constitution, then that's the way to do it. But it cannot be done by legislative action consistent with the
So
Constitution.
just to be clear, we'd have to relook at the Constitution to go and get this change for accountability.
Similar to what was done to carve out the exceptions. It used to be that all offenses except for those, I think the death penalty, there was right to bail, right? But by constitutional amendment, those two narrow exceptions were drafted and amended into the Constitution. So yes, it is
This is like in the early 90s, right?
early 90s, yes.
That was last amended. So the other option is not to, go too much of a tangent, is to get the courts working so that cases are moving through the court in an expeditious manner, which has been a focus in part because of the restrictions that we face in the Constitution.
You really want to go there with me?
I'm just saying, Ian.
Can I just ask one other question before you move on?
Marty.
I've never really considered the question of like if you were on conditions of release while your case was pending, and you had violations of your conditions of release, and then you were acquitted,
Mhm.
that would have any bearing on whether those violations of conditions of release should not be like separate criminal charges.
Yeah.
I kind of, my understanding is like, you get those conditions, if you violate them, those are separate charges, they have to be adjudicated. I just asked if there's anything around that, based on your point on subsection 2 on page 4, line 6.
Yeah, no, I mean, I want to be able to say they all disappear automatically,
They don't, though.
but I don't believe they do. Now, if I'm wrong, I'll come back and correct.
I would be
But,
very curious. This had never occurred to me, but
Are they in practice dismissed? But again, in this moment, and I'm just having a moment of brain fog, I can't tell you that they're going to be dismissed automatically. All right, so if I can now shift to this significant definition, addition, disrupt the prosecution. It's defined on page 4, starting on lines 13, but it's defining the term as it's inserted into page 2, line 8. And that is picking up the language as best as I can see where this comes from Gates and Saw, right? Instead of impedes the prosecution, those decisions uses disrupts the prosecution. And in fact, State v. Gates is actually, to be precise, is more specific. And this is what I would say. It's not disrupt the prosecution of the accused. And what docket are you talking about disrupting the prosecution of the accused? The bazillion dockets that are pending involving the defendant, the accused? State v. Gates answers that. It disrupts the prosecution of the underlying crime. And that's paragraph 16. Again, they use the term underlying crime. The focus is to get to the heart of it. The focus is to stay centered on what started this prosecution, not the spin-offs where there's violations of conditions that are based from the underlying crime. So disrupts the prosecution of the underlying crime. If you're going to go forward and change this, you should make sure that's in fact consistent with State v. Gates. Get underlying crime in there on line 8, page 2. All right, so page 4, the definition of disrupts the prosecution. Again, Gates and Saw make clear that this has to meet the definition constitutional for. And those decisions set forth that there must be a compelling and legitimate state interest before there is a revocation. Compelling and legitimate state interest. Well, what is that? The Supreme Court tells us. Supreme Court says there must be a nexus between defendant's actions and the disruption in the prosecution of the underlying crime. A nexus. Can't be just, again, this is why violations of conditions of release standing alone aren't enough. It has to actually have a connection to, direct connection. Destruction of evidence. Remember, these are the examples they gave us in these decisions. Intimidating a state's witness, right? Interfering. Again, directly connected to the underlying case. So here, let's look at what's going on. You can see by focusing on the first part, disruption of the prosecution means in addition to whatever else it's set forward, I say this also sets another way to do it, right? Another definition. This definition is not consistent. Merely committing a criminal offense, right? We know from Gates and Saw that's not enough. Remember, Gates, paragraph 22 said committing a felony. Similar, committing a felony is not enough. Committing another offense. Solve multiple violations, conditions of release, or a single one. Here, this one just allows a single one to be the basis for revoke. Again, already considered, rejected by the Vermont Supreme Court. So then what's happening in the second part and line 816 and? I don't understand this part. This part doesn't require a nexus to the defendant's actions, right? Nexus between the defendant's actions at issue and the disruption in the prosecution of the underlying crime. Instead, this is sort of language similar to Salerno, Eighth Amendment, least restrictive restraint on a person's pretrial liberty interests, least restrictive constraints. That gets nothing to focusing on what is the action at issue and whether it disrupts the prosecution. Does that make sense? So it's borrowing language from various places, but that's concerning making sure that if you're going to deny release on your own cognizance or right to bail, that whatever you do impose is the least restrictive. In the revocation context, you have a right to release, right? If you're going to revoke it, you have to make sure that whatever the person did is directly connected to the disruption of the prosecution of the underlying crime. This definition doesn't meet it. It doesn't do anything but expand revocation in areas unsupported by the case. I think that's it that I have here.
So a question, just on that language of the disrupt language, I understand what the underlying crime, but it would seem, what I find possible that it makes sense is the mitigating the defendant's risk of flight from prosecution, because that I could see that nexus going with the integrity of the process and the prosecution's ability to proceed with the case. Yeah, the reasonably mitigate the defendant's risk of public safety, to reasonably ensure the defendant's compliance with court orders, that, you know, you could keep that, but it once again has to have the nexus that you're talking about.
That's right.
And I've kind of wondered actually that these arguments seem to be available to prosecutors right now. And I wonder, you know, are they making these motions that lays out multiple violations of conditions of release, person not showing up, that, and this is keeping us from being able to prosecute this case? Are they making those motions that you know of? And if they are they just being denied? And then there's not a route to appeal for us to actually get the Supreme Court to weigh in on something besides the witness intimidation, because that's the only thing that, or evidence, damaging evidence.
I don't have numbers to share in terms of how many of these are being filed. I am not aware that there is a problem with the state feeling they can't file a motion to revoke and make those arguments that you're saying. In terms of whether or not there's an available, or is it just disappearing? Is there no route to an appellate review? There is. I mean, these decisions came up from a revocation decision based on a motion from the state, and that's
But if they're denied, is there a route for appeal other than an interlocutory?
Oh, I see. If the state can appeal it, I'd have to look at, there's the statute that sets forth when the state can appeal certain actions and when it's not final on, and I just have to review it. I can't off the top of my head right now come up with a decision where the state has appealed the issue of it. I just can't.
Okay, that's fine.
There might be, yeah.
That's fine. Any other questions for Rebecca?
Just a very brief one, page 3, line 4, to be on the evidence, for it being sworn affidavits. I guess why, so weighted the evidence hearings, I think they can use affidavits and sworn statements.
Admissible evidence.
Yeah.
Yes.
So could you make an argument that a weight of the evidence is kind of like the inverse of this? Like there's been an adjudication that someone's held it out and now they're challenging that to try to get out.
Mhm.
And in this instance, it would be, there's been an adjudication that they don't have bail or that they have bail and now bail's being revoked
Mhm.
and they're basically having the same hearing. And the court's already heard evidence, probable cause, has been determined. Now they're having sort of this secondary hearing.
So is your question,
Is that, maybe
they're
I'm not
so
clear.
different. No, they are. I think that you're pulling from different proceedings with different standards, right?
Yeah,
And different
fair.
evidence support. And I think that is the answer to your question. They are so different.
They're so different
Right.
that it's not.
That it is in part, again, what is at issue here is pretrial detention.
Yeah.
When the presumption of innocence applies, and when the basis for it can be not even a crime itself, right? And so that was why the Supreme Court landed on the preponderance standard, a higher standard than mere probable cause, right? And also is linked with the live testimony requirement.
Yeah.
It's just trying to ensure the protections are built in, that it's the right to bail. Again, the right to bail is embedded in the presumption of innocence principles is just not undermined.
Yeah.
I think there are different considerations and interests involved at the weight of the evidence hearing is what I'm trying to say, that warrants how those different standards developed in that proceeding.
Very good.
Yeah.
Perfect. Thank you so much.
All right, thank you.
So, we'll get started again at 10:30. Please absolutely be back here at 10:30.